and that is the issue why all of us are before this litigation. You need to advise the advocate general. You need to advise your officers the manner in which they have to draft.
Yes. And one is, of course, you are not a party, then principles of natural justice not followed. You are not aware of that paper publication notice. And that even if the case has attained finality, it is not against you. It's a judgment in rem, not a personam, not in rem. And that para 127 post this, prospective overruling. So all these points we have taken note of. So you need not labor further on.
I know. Only one thing, that 127 prospective overruling is on the basis of doctrine of prospective overruling adopted by this one.
That we understand.
Okay. Therefore, the affirming by Supreme Court judgment, affirmed by Supreme Court means, including this paragraph 127, means I am protected, my lord. That is why I have encouraged.
We have taken that.
And my lord, Honorable Justice Lodh also has pointed out one thing, that principle of natural justice is not a straight jacket formula. I appreciate, my lord. That is formula, I agree, my lord. But neither in the administrative order, termination order, nor in the judgment it is there that for such and such reasons I am not entitled. Therefore, if the Article 14 and 21 is this fundamental right, procedural right is in Article 311(2). There are specific grounds given under what circumstances notice can be avoided, my lord. That is my last point. Article 311(2) is the procedure. That is the fundamental right. They have not followed it.
That won't apply in this case. You are not being dismissed by invoking 311 or the exception to 311.
But if I am in service, I have a right under Constitution. And let me read, my lord, with any permission, your lordship.
Mr. Shah, you are missing the point. See, in personam, if at all your services are terminated or they are faced, if your client is facing an adverse order, fine. But at large, the entire procedure of selection has been set aside. So where is the question of again coming back and issuing a notice? In my judgment and even in the review order, where I clarified, I only said they could have given a detailed note of the procedure of Supreme Court and High Court judgment and some facts. Because even when I read, I couldn't follow it. That was the only observation made. But it was not an order in your favor. Your favor in the sense, a teacher's favor. No.
My lord, that is my case. Your lordship has rightly understood that if two interpretations are possible, which favors me, that may kindly be adopted, and it is my fundamental right, your lordship. And my lord, this is not a paper right, this fundamental constitutional right. There is a rule of law, my lord. There is my humble submission. If this is the rule of law, constitutional rule of law, that may kindly be upheld, your lordship. I am before your lordship. This is my humble submission on behalf of petitioner. This appreciation can be allowed.
Yes, learned advocate.
May it please your lordships. My lord, at the first instance, my lord, I will thank Mr. Saha. It's for him, my lord, that we are before your lordships today. My lord, having said so, I must say one thing. It's an adversarial proceeding, and my submission will be adversarial. My lord, this will be probably the 12th or 13th petition proceeding after Tanmoyanath was decisively decided, after Vijay Krishna came in. My Lord Justice Lord, in one occasion, I was there in the court, had warned openly, my Lord, of course, at the insistence of both the party lawyers, desisted from writing it, that instead of spoiling our time in the corridors of the court, gentlemen, advertisements are coming out. Why don't you study and apply for that? You have already got some leverage from Supreme Court, which is recorded in two judgments. One, the solace judgment of my Lord Justice Lalit. First objection to the present proceeding and the writ petition is a cavalier petition, as my reference, Vijay Krishna is there. Is the first. My Lord, may straightway come to page 17 of this compilation, which is also the running page 17 of the judgment. Page 17, bottom of paragraph 3. Lordship got it, my Lord, kindly come to A, B, and C, last line. His clients were never informed of the pendency of any proceeding or implicated as parties therein, and as such, his clients would not be bound by the decision dated so and so, referred by this court in Tanmoyanath Supra. My Lord, kindly come to page 28 straightway for the answer of their lordships. Page 29, my Lord. Page 29, findings start at page 28, page 29, bottom, paragraph 18. Lordships got it, my Lord. Paragraph 18, bottom. As such, at this stage, instant writ petitioners cannot be allowed to reopen the entire issue purely on the ground of their non-implementation as parties or non-issuance of notice to them. Who are the petitioners? Are they illiterate rustic villagers hailing from most deprived strata of the society, having no access to justice, also not knowing its procedures? Most certainly not. They are educated government employees posted at several places of the state. Can it be said that they were not aware of the proceedings laying challenge to the appointments made in regard to more than 10,000 posts of different categories of teachers appointed by the government pursuant to the advertisement issued in 2002, 6, and 9? The answer obviously lies in the negative, and the reason is twofold. The pendency of the original writ petitions were widely circulated, and we are informed throughout the state, both in the print and electronic media. So also was the outcome made known. It sent ripples throughout the state. Not only that, prior to rendering of the judgment of Tanmoyanath, this court had directed issuance of notice to be published in newspaper, which was also done. There is no factual, my lord, rebuttal to all this. To contend that such directions or notice were confined only to in respect of certain categories of teachers, and as such cannot be construed to be notice qua their categories, is not acceptable. My lord, this is also not their case. That I don't fall within the category of teachers whose appointments were under challenge or, my lord, set aside. It is true that in a service matter, principles laid down under Order 1, Rule 8 CPC may not apply, but then this court was dealing with a case where it stood to observe that the action of the government as a cruel joke on the people of Tripura. The entire selection process was held to be absolutely arbitrary, capricious, and whimsical. It smacks, my lord, these words fell from your lordships at the very beginning. It smacked of nothing less than nepotism and favoritism. Prudently, the writ court thought it fit to issue a general notice and not impede all the 10,323 selected teachers as party respondent, some of whom in any case were before this court, while not almost thousands of them were before the court. In a representative capacity, the petitions were considered, argued, and decided. Significantly, none of the instant petitioners laid any challenge to the judgment made in Tanmoyanath. Neither did they seek review, nor did they file any appeal. Why so? Remains a sordid secret. With the dismissal of the SLP and their appointment conclusively found to be illegal, they ought to have been returned home, but for extensions granted by the Apex Court by order written so and so. Even at this point, they did not express their concern or raise any protest. They are all beneficiaries of this, my lord, process. When the benefit came, they were not telling that I am not an OTC. Why do you terminate my service? Or why do you even extend my services? My services are there. Why do you extend them? Obviously, they were waiting in the wings, and only when they fell out of favor of the Lady Fortune, inasmuch as time extended by the Apex Court is expiring and otherwise not having qualified, they took steps speculative in nature of having the entire issue reopened by challenging the judgment in Tanmoyanath Supra. We find their act and conduct to be absolutely despicable. My lord, I stop here. Even after this judgment,
Yes.
paragraph 20 is also relevant. I'm not reading, my lord, your losses of that. Even after this strong judgment of a division bench of this honorable court, if someone comes with a writ, that too bereft of any factual foundation, so as to bring a case before the, my lord, adjudication periphery of this court, that I am different, and these are points number 1, 2, 3, why I am different. They never say Vijay Krishna doesn't apply to me. They never told Tanmoyanath, my lord, Tanmoyanath is not a judgment in rem. I am not within Tanmoyanath. They never say so. My lord, what do I call such petitions? Is it not a cavalier petition? If it's a cavalier petition, my lord, the question will be, what penal consequences will follow? Because we had enough of it, my lord. Since 2019, we had enough of this. Petitions after petitions. Every time your lordships are reiterating that here and no more. Now this here and no more must be in terms which can be expressed most sternly by your lordship, my lord. Not only despicable. It must come out with a penal consequence.
therefore constituted a successful bench to hear the matter. Also take into consideration that at present this court is functioning with a strength of 3 judges only, 5 sanctions strength. Stop me. And that institution of a division bench at the first instance may not have resolved the issue decisively. Stop. Para. The appointees to the post of teacher under the advertisements of the advertisements of 2002, 2006, and 2009 appear to revive the issue relating to the termination of their employment even after the finality reached to the issue by virtue of the judgment rendered by a learned division bench of this court in the case of Tanmay Nath, Nadar Sukha, and other analogous cases dated 51 of 2014, dated and the matter having been finally affirmed by the apex court in its judgment dated 29 March 2017 in SLP Civil so and so and other matters. So, briefly stated, the entire selection process under the selection process to the post of teachers within bracket undergraduate, graduate, and postgraduate under the advertisements of 2002, 2006, and 2009 were in question before this court in the case of Tanmay Nath and others on a number of grounds, the main ground being the legality and virus of the revised employment policy 2003, under which the selection process had been undertaken. Stop. Perusal of paragraph 4 to 10, 8 of the judgment in the case of Tanmay Nath would show that all those teachers, that is undergraduate, graduate, and postgraduate, involving how much? 10,123.
10,323.
Involving 10,323 teachers were under question before this court in the case of Tanmay Nath. The learned division bench of this court comprehensively dealing with the matter and the rival contention of the parties inter alia, set aside the entire selection process by declaring the revised employment policy of 2003 as unconstitutional. So, a set of directions were issued, which are contained in paragraph 123 to 129.
aside is 122. Setting aside is 122, future course 123 onwards.
121, 122, or so the directions from 123 onwards till 129. The state and certain aggrieved writ petitioners went in appeal before the apex court. Stop. The operative direction relating to the at para 123, were our state by the apex court. Stop. By the judgment dated 29 March 2023, 2017, the apex court dismissed the special leave petitions. However, with certain modifications, in para 123 of the impugned judgment, judgment dated 29th March 2017 is extracted, quoted here in below. Stop. By virtue of the judgment dated 29th March 2017, the services of all those teachers, including the present petitioner, who was one of the selectees under the same recruitment exercise as a graduate teacher, were terminated by order dated 31st December 2017. Stop. The order in the case of the present petitioner is annexure 5 at page 23 and reads as under. The apex court, by virtue of the interim orders passed by the apex court at the on the request of the state of Tripura, the teachers whose services were terminated were granted extension for ad hoc extension, appointed as graduate teachers on ad hoc basis from 1st January 2018 for a period of 6 months, which continued up to 31st March 2020 by virtue of the order dated November 2018, passed by the apex court in content petition civil numbers 1706 of 2017, in SLP civil numbers 18193-19049 of 2014, and with miscellaneous applications and other connected matters. The order dated 1st November 2018 is also extracted here and there for better appreciation. By virtue of the interim orders passed by the apex court, these persons, including the petitioner, continued on ad hoc basis till 31st March 2020. By the impugned order dated 31st March 2020, Annexure 11A, the petitioner was informed that his ad hoc services were terminated with effect from 31st March 2020. Petitioner has thereafter approached this court in the present writ petition referred on 10th October 2022, assailing the termination letter dated 23rd December 2017, and also Annexure 5 and the termination letter dated 31st March 2020, Annexure 11, issued by so and so. Stop. In order to complete the narrative, it would also be proper to refer to another batch of litigation on the same issue initiated by some of the teachers. That is WPC number 1, Vijay Krishna Saha and others versus State of Tripura and others, WPC number 1040 of 2019, and other connected writ petitions. In the said batch of writ petitions, the petitioners though were beneficiaries of the same appointment process on as undergraduate / graduate / postgraduate teachers. Claim to be not bound by the decision rendered in the case of Tanmay Nath as affirmed by the apex court, inter alia contending that A, those petitioners were appointed in March 2010, before which date they had acquired the eligibility in terms of notification issued by the state of Tripura under the NCTE Act 1993, B, semicolon B, in terms of the selection process undertaken by the state. The petitioners were appointed as graduate teachers. C, the petitioners were never ever informed of the pendency of any proceedings or included as parties and are therefore not bound. Decision dated 7th May 2014 rendered in the case of Tanmay Nath that presentations stood summarily rejected. This court, a division bench of this court, of which one of us within bracket, Arindam Lord J, was a member, dismissed the writ petitions dealing with holding that the present those bunch of writ petitions were an abuse of the process of law and speculative in nature. The aforesaid contentions raised by the petitioners in the case of Vijay Krishna Saha and others were also squarely dealt with in the body of the judgment. The ground of non-implement as parties or non-issuance of notice, them were also discussed at paragraphs 18, 19, and 20. Those petitioners had also raised the issue relating to protection under relying upon para 127 of the judgment of Tanmay Nath. That contention was also dealt with at paragraph 23 to 27 of the judgment dated 3rd October 2019. It also needs to be mentioned here that by order dated February 2014, in the case of Tanmay Nath, notices were issued to all through paper publication in the light of the principles contained in Order 1, Rule 8 of the Civil Procedure Code. The decision in the case of Tanmay Nath was thus rendered in respect of the entire selection process under the advertisements of 2002, 2006, and 2009, and conducted in terms of the new revised employment policy of 2003. So, the Ghana division bench in the case of Tanmay Nath found several illegalities and lack of proper guidelines, leading to latent cases of arbitrariness in the selection process, and was compelled to set aside the entire selection process undertaken under those advertisements relating to graduate, undergraduate, graduate, and postgraduate. So, when the matter was brought to this court, when the relating to when the termination of the ad hoc services of one of the teachers, that is some of the teachers, that is Pradeep Devramma and two others, in WPC number 34 of 2021, was brought before this court. So, one of us within bracket P. Amarnath Gorje, while after dealing with the rival contention of the parties, found that the memorandum dated 31st March 2020 was not a speaking order, and rather an omnibus communication to set aside with the liberty to the respondents to pass a specific order in the subject matter relating to the petitioners. Petitioners, if agreed by the said decision, were granted liberty to avail remedies under law. The state preferred a review petition against the said judgment, which was heard and decided by Brother Justice God, inter alia, holding inter alia, holding as under paragraph 6 to 8, 9, 8 to 10, sorry, from 6 to 10. So evidently, it was made clear that the court had not granted any relief in favor of the writ petitioner for providing them any appointment or to continue with their services as teachers. So, this, the decision of one of us, that is P. Amarnath Godje, was brought the notice of the other writ court decided over by one of us, which is Lord J, in the case of the present petitioner, that is the present writ petition. Whereafter, the learned court referred the matter to Honorable the Chief Justice to constitute an appropriate bench to decide the rest. That is how this is stopped. Learned counsel for the petitioner para has assailed the impugned termination letters dated so and so, annexed 5, annexed 11A, on the following grounds. A, that the petitioner was not a party in the writ petitions decided by this court in the case of Tanmay Nath and other connected petitions dated so and so. Two, that no notice before termination was served upon the petitioner, asking him to submit his defense reply before the petition was passed. As such, there is a violation of principles of natural justice. Then counsel for the petitioner has sought to rely upon the decision of the apex court in the case of Gandhi versus so and so in support of his submission as regards requirement of compliance of principles of natural justice as it entails adverse civil consequences. Small 3. Petitioner has also, then counsel for the petitioner has also placed reliance upon the decision, upon paragraph 127 of the judgment in the case of Tanmay Nath in order to submit that since petitioner was not a party in those writ petitions, by the principle of prospective overruling, the case of the services of the petitioner were saved. So, and counsel for the petitioner has therefore submitted that the services of the petitioner have been terminated in violation of principles of natural justice. So it entails adverse civil consequences, and he was not a party or covered by the decision of this court in Tanmay Nath or before the apex court, where the judgment was affirmed. So, the writ petition is not barred by delay, as not only there is no period of limitation prescribed in writ jurisdiction for invoking writ jurisdiction, and further his services were continued till 31st March 2020. Then counsel for the petitioner has also referred to certain presentations and applications made for furnishing information under RTI before the authorities of the state, which have not been heeded. So he has also referred to certain certain answers obtained under RTI from the Supreme Court registry to the effect that the petitioner was not a party in the petition number so and so arising out of before the apex court arising in the case of Tanmay Nath and others. Substance is the case of the petitioner that the decision of Tanmay Nath does not cover the case of the petitioner, and as such, his services could not have been terminated without proper show cause notice and without consideration of his defensive client. Learned Advocate General has strongly opposed it. He submits that the petitioner has not been able to make out a clear case through the pleadings of the writ petition that he was not covered by the category of selectees or teachers belonging to undergraduate, graduate, and postgraduate of belonging categories of teachers that is undergraduate, graduate, and postgraduate, as have been dealt with squarely under paragraph 4.8 of the decision in Tanmay Nath. Stop. The writ petition is an abuse of the process of law, as petitioner has failed to show as to how his case is distinguishable or segregated from rest of the teachers whose appointments were set aside primarily on the ground, whose selection process was set aside primarily on the ground that the revised employment policy 2003, under which the recruitment exercise was undertaken under advertisements of 2002 to 2009, were found to be arbitrary, illegal, and suffering from nepotism and favoritism. So it is submitted that the decision of Tanmay Nath has been rendered is a judgment in rem, and no individual teacher can claim to be accepted from the rigors of that decision, which has been confirmed up to the apex court. The petitioner can also not complain that that no notice was served upon him, as by virtue of the order dated so and so passed in the case of 6th February 2014, passed during the proceedings of Tanmay Nath's case. Notices were issued to all such teachers to paper publication in line of the principles contained under Order 1/8 of the CPC. Stop. And the Advocate General has also placed the decision of this court, division bench statement of this court in the case of Vijay Krishna Shah and others, where the same contentions have been raised and squarely dealt with, answered by this court. So it is submitted that petitioner has the decision in Tanmay covers 10,323 teachers. The petitioner is also one of them. As such, the plea of non-compliance of principles of natural justice or opportunity to show cause does not arise in the case of individual petitioners when the entire selection process has been set aside. The Council, Learned Advocate General has also sought to rely upon certain decisions. Sought to rely upon the decisions which have already been referred to in the previous part of this judgment. So, we have given anxious consideration to the rival submission of the parties. It needs to be mentioned at the outset that by virtue of the judgment rendered in review petition number 40 of 2023 by one of us within bracket T. Amarnath J, it has been abundantly made clear that the writ court had not granted any relief in favor of the writ petitioners for providing them any appointment or to continue with their services as teachers. So, the referral order dated 30th May 2023 passed in WPC number 893 of 2022 has elaborately discussed the referred to the judgments rendered by this court in the case of Tanmay Nath and others, Sri dated so and so, Sri Vijay Krishna Saha and others, dated so and also the judgment of the Apex Court dated 29th March 2017, whereby the case of whereby the decision in Tanmay Nath was affirmed. Certain modifications in paragraph 123 of the order of the judgment in Tanmay Nath's case. However, since at the fag end of the order, it was the judgment passed in WPC number 334 of 2021 was brought to the notice of the learned court. The matter was referred to Honorable the Chief Justice to constitute an appropriate bench to do the case. After hearing learned counsel for the parties at length and after giving anticipation to the rival submission of the parties and the points raised, we are of the unanimous view that the issue of legality of the appointments undertaken under advertisement number of 2002, 2006, and 2009 in terms of the revised employment policy of 2003 have attained finality by virtue of the judgment rendered by the Apex Court in the case of so-and-so dated 29th March 2017, whereby the decision of the division bench of this court in the dated so-and-so in the case of Tanmay Nath has been affirmed. The entire selection process, the relevant paragraphs of the judgment in the case of Tanmay Nath had already been quoted here and above. The order of the Apex Court dated 29th March 2017 and the interim order passed thereafter by virtue of which ad hoc extensions were granted to the teachers like the petitioner to continue till 31st March 2020 have also been referred to here in above. Stuff. The decision in the case of Tanmay Nath is a judgment in rem which operates as regards all the appointees, selectees under the advertisements of 2002, 2006, and 2009, and covers 10,323 teachers of different categories, that is undergraduate, and postgraduate, including the present petitioner. Petitioner it is not that proper notice was not issued upon all the appointees / selectees under the aforesaid advertisement, as by virtue of the order dated 6th February 2014 in the case of Tanmay Nath, notices were issued to all through paper publication in terms of order 108 of the CPC stuff. It appears that this petitioner, despite valid notice, did not choose to intervene in the batch of writ petitions decided in the case of Tanmay Nath, nor did he approach this court earlier after the termination order dated so and so annexure 5, and continued to enjoy the ad hoc extensions to his service till 31st March 2020 in terms of the order passed by the apex court. Stop. The present case of the petitioner is not one where his services have been terminated on charges of misconduct, where the principles enshrined under Article 311 of the Constitution of India can be read in. Stop. The entire selection process was set aside as the revised employment policy of 2003 suffered from various illegalities, arbitrariness, lack of guidelines, arbitrariness, favoritism, and nepotism in the process of appointment. So, the learned division bench of this court had directed fresh policy to the employment policy to be framed and selection process to be undertaken, fresh selection process to be undertaken after giving some relaxation to the appointees whose services were terminated. So, it therefore doesn't lie in the mouth of the petitioner to contend that the impugned termination orders dated so and so are suffering from violation of principles of natural justice, and that petitioner is not covered by the judgment of this court in case of Tanmay Nath as affirmed by the apex court. So, in fact, the contention of the petitioner relying upon para 127 of the decision of Tanmay Nath also has been squarely dealt with by the division bench of this court in the case of Vijay Krishna Shah, and the reasons are the secrets. As is apparent from a reading of para 127 of the para 127 of Tanmay Nath's case, it can't be read in isolation from the preceding paragraphs starting from paragraph 121, 122, and the nature of directions passed by the court contained in paragraph 123 to 126 of the judgment. So, it is quite obvious that since several employments could have taken place under the revised employment policy of 2003 concerning other departments which were not before the court in the case of Tanmay Nath, within bracket, which covered the case of teachers under education department only, the learned court was conscious. The learned court consciously clarified that this decision would operate prospectively unless, as regards other appointments, unless This, the judgment would operate as regards the appointments made under the advertisement dated 23rd March 2009, 23rd September 2009, unless any employment made in any other employment made under any other department was already under challenge on grounds of on the ground that the employment policy is illegal. As such, para 127 does not confer any benefit or leverage to the present petitioner to escape from the rigors of the decision rendered by this court in the said case as affirmed by the apex court. Stop. The litigation journey, as observed at the outset, has gone for almost 12 years by now, since the first writ petition was filed in the year 2011. The beneficiaries of that selection process ought to have obeyed the judgment of this court in the case of Tanmay, and as affirmed by the apex court by judgment dated 29th March 2017. Instead of raking up the issue, taking up their grievances on non-issues, this court therefore deprecates the approach of the petitioner indulging in an abuse of the process of court once the decision of this court has attained finality by virtue of the judgment rendered by the apex court, and none of the points raised herein are such novel points which are available to be raised by the petitioner. As observed herein above, we are of the unanimous view that no interference is called for in the impugned orders, whereby the services of the petitioner have been terminated. Stop. The writ petition is therefore, the reference is answered accordingly. The instant writ petition is dismissed. Dismissed with a cost of 25,000 to be deposited in the state legal services.
They are unemployed.
They should be conscious, and others also should become conscious.